Good afternoon, everybody. I'm Steve Tates along with Pat Barry, and we're here for the MBA's presentation for July of 2021, live from the Inspirin Studios at Brightech. Today's presentation, Cannabis, the Long and Winding Road, Ancient Medicine to Growth Industry.
Today we're very pleased to have with us Sean McGowan, who is a partner at Kaufman McGowan, Corporate and Securities Counsel to the State-Legal Cannabis Industry. Kaufman McGowan is based in Hauppauge, Long Island, and is one of the leading corporate cannabis law firms in the United States. They represent several of the world's largest cannabis investors and operating businesses. Mr. McGowan and his firm combine decades of practicing corporate and securities law at the highest levels with extensive cannabis industry experience. In particular, Mr. McGowan represents various emerging growth, middle market, and public companies and investment firms in their corporate securities, financing, borrowing, merger, and acquisition, and other legal matters. Like my co-host, Mr. Tates, Mr. McGowan has a long list of other achievements. We are a little disappointed that there are no samples here today, but we are pleased to have him in studio with us to talk about the cannabis industry. Now we turn it over to Sean.
This Alliance for inviting me here today. My name is Sean McGowan, and I'm a partner at Kaufman McGowan PLLC, one of the leading corporate cannabis law firms in the United States. When I graduated law school, I never would have thought I'd be here right now in the middle of this rapidly developing and burgeoning industry full of immense opportunity. I got started in the cannabis industry about 6 or 7 years ago. We started with one client, which gave us the opportunity to really learn the ins and outs of the industry. From there, the cannabis side of our practice really took off. Since then, I and the attorneys at my firm have obtained extensive cannabis experience, including participating in approximately $2 billion in cannabis industry transactions, negotiating and closing numerous acquisitions, representing clients in connection with their state license applications, and structuring many corporate groups. So today we're going to talk about and focus on 3 topics related to the cannabis industry. First, I'm going to provide you with an overview of the history of cannabis and how we got here today. If you're not familiar with it already, I think you'll find that the story of this plant, which is often forgotten or at least not told enough, is fascinating. At a minimum, I think it will set the backdrop for the rest of the discussion. Second, I'll provide a high-level summary of the state of the legal cannabis industry at the federal level. And finally, I will provide you with a review of the Marijuana Regulation and Taxation Act, which was signed into law by Governor Andrew Cuomo on March 31st, 2021, and what we know about it so far. So, with that, let's go back just a few years, about 8 or 10,000, to where some of the oldest evidence of cannabis use has been found. For over 10,000 years, ancient cultures in China, India, Egypt, Persia, and elsewhere have used cannabis for a variety of medical and industrial purposes. We can trace its use in China back at least 10,000 years to hemp cords found in Taiwan. There is also evidence of cannabis seeds and oil, as well as hemp-based textiles in China and Turkestan about 6,000 BC. By 2900 BC, Chinese Emperor Fuxi, the father of Chinese civilization, noted that ma, the Chinese word for cannabis, was a very popular medicine that possessed both yin and yang. The Pen Sao, a Chinese digest of herbal medicines, which was first published in or about 2800 BC, recommended cannabis for the treatment of constipation, gout, malaria, rheumatism, and menstrual problems. In fact, hemp was so important in ancient China that the Chinese people referred to their country as the land of mulberry and hemp. By about 2000 BC, ancient Egyptians began using cannabis to treat sore eyes and cataracts, inflammation, hemorrhoids, menstrual bleeding, and glaucoma, and appeared to have been the first to identify it as a treatment for cancer. Interestingly, in the book of Exodus, cannabis, referred to as cannabosum, was purportedly one of the ingredients contained in the holy anointing oil passed from the God of the Bible to Moses. The Venedad, a Persian text dating back to 700 BC, cited cannabis as being one of the most significant of its 10,000 medicinal plants. The ancient Greeks used it for earaches, edema, and inflammation. And by 200 AD, a Chinese physician, Hua Tuo, became the first known surgeon to use cannabis as an anesthetic during surgeries, including organ grafts and resectioning of intestines, incisions into the loin, incisions into the chest. So I hope that you can see that any claims that cannabis does not have any medical value seem to be unfounded. So China appears to have been the first civilization to use hemp for paper. Between 900 AD and 1200 AD, the Arab world, Spain, Italy, England, France, and Germany all began replicating China's hemp paper manufacturing process. The Venetian Republic, the first European empire to emerge from the Dark Ages, industrialized around processing hemp into rope, sails, and fine linen-like cloth. This reliance upon cannabis to produce industrial hemp lasted well into the Middle Ages and spread all across Europe. Britain became the industrial Goliath of Western Europe, in large part due to its exploitation of hemp for its merchant and naval fleet. Hemp became so important to the British economy that British kings mandated hemp cultivation by domestic farmers, immigrants, and early American colonists. If quotas weren't met, farmers were heavily penalized. It was so important that Parliament even passed legislation granting rights and privileges of natural-born citizens to any foreigner who settled in England or Wales and established a hemp-related industry within 3 years, in order to encourage those fleeing persecution in Europe and to seek refuge in England. So jumping a little bit, a combination of America's first textile and shipbuilding industries created a burgeoning domestic market for local hemp, which led colonists to retain the vast majority of American raw hemp for their own local production of rope, paper, and cloth, rather than export it to England. Hemp was so instrumental in the colonial American economy that it was often used as a barter currency. Some believe that early drafts of the Declaration of Independence and the United States Constitution were written on it. Many of the supplies and uniforms needed for the Revolutionary War were made from it, and the first United States flag was made from hemp cloth. In fact, all official American flags were made of hemp until 1937, when Congress enacted the Marijuana Tax Act, which we will discuss later. Some of the founding fathers smoked cannabis, known at the time as hemp or sweet hemp, for both medicinal and recreational purposes. There are entries from George Washington's diaries that reveal that Washington grew hemp at his plantation in Mount Vernon for approximately 30 years. These entries can be found in the Library of Congress, which I think is pretty cool. Thomas Jefferson also grew hemp and smoked it for his migraines. James Madison is reported to have stated that sweet hemp gave him insight to create a new and democratic nation. Beginning in the 1830s, cannabis-based products such as Squire's extract and Tilden's extract became popular medications. By 1850, the United States Pharmacopoeia, a highly selective listing of America's most widely taken medicines, listed cannabis as a treatment for many conditions, including convulsions and opiate addiction. Also, by 1850, hemp had dropped from the first to the third most commonly grown agricultural crop in America, behind only slave economy-driven cotton and tobacco. In 1860, the Ohio State Medical Society's Committee on Cannabis Indica found cannabis to be medically effective for ailments including stomach cramps, coughs, venereal disease, postpartum depression, epilepsy, and even asthma. And by the latter half of the 19th century, every pharmaceutical company in America was busy manufacturing cannabis-based patent cures, including E.R. Squibb & Sons, Park Davis, and Eli Lilly. America saw this cannabis fad in the mid-1800s among intellectuals, but like all good things, you knew this had to end. So in the 1890s era surrounding the Spanish-American War, yellow journalists led by the Hearst newspapers began publishing anti-cannabis articles with fantastical tales of horror. When the Mexican Revolution resulted in a wave of Mexican immigrants to America's southern border states in 1910, articles in the New York Sun, Boston Daily Globe, and other papers decried the evils of ganja smoking and suggested that some immigrants used it to key themselves up to the point of killing. This wave of hysteria, fed by anti-immigrant xenophobia, resulted in many states making cannabis illegal. William Randolph Hearst, who had substantial interest in timber companies that could be harmed by hemp, fed this wave. Having his 28 newspapers drop the term cannabis and use only marijuana, a slang term intentionally used to associate cannabis with Mexican immigrants. There were also rumors that the DuPont chemical family, the company that invented nylon, sought to reduce their exposure to hemp competition by supporting this anti-cannabis wave. So what you have here is, by the 1930s, several anti-cannabis dynamics were dangerously at play, such as, by 1931, 29 states had made cannabis illegal, starting with our hometown, New York, in 1906. The economic pressures of the Great Depression intensified the anti-immigrant and anti-Mexican xenophobia promoted by Hearst and his yellow journalists. And the end of alcohol prohibition left the Federal Bureau of Narcotics looking for a justification for its existence. So in steps Harry J. Anslinger, the man most responsible for American anti-cannabis laws. Anslinger was an anti-corruption bureaucrat who actually started out pro-cannabis. Anslinger was the first commissioner of the Federal Bureau of Narcotics, which was the predecessor agency of the FBI. However, as Prohibition ended in 1933, he realized that heroin and cocaine were not enough to support his department, and he began to aggressively advocate a nationwide ban on quote-unquote the evil weed. He authored sensationalist articles eagerly published by the Hearst newspapers. Anslinger especially liked to cite the story of Victor Licata, who supposedly massacred his family because he was a marijuana smoker. As it turned out, Licata had a serious mental illness and did not use cannabis, but those kinds of details did not stop Anslinger. When 29 out of 30 pharmacists and drug reps objected to his proposals, he discarded the 29 objectors and repeatedly cited the single biased dissenter. So, when you think about it, why would an otherwise seemingly upstanding public official act like this? Well, this is quite clearly explained in Anslinger's own words, and I'll spare you the incredibly disgusting, disturbing, racist comments. But if you're curious, they're widely available on the internet. So, we have all heard about the 1936 film Reefer Madness. And this is yet another example of the hysteria and propaganda that was being fed by Anslinger. And I have a clip, which I think you might enjoy. It's more of a trailer from the film. So,
in this film, you will see the ease with which this vicious plant can be grown in your neighbor's yard, rolled into harmless-looking cigarettes, hidden in an innocent shoe or watch case.
If you want a good smoke, try one of these.
You will meet Bill, who once took pride in his strong will as he takes the first step toward enslavement.
Of course, if you're afraid.
Smoking the soul-destroying reefer, they find a moment's pleasure, but at a terrible price. Debauchery, violence, murder, suicide, and the ultimate end of the marijuana addict. Hopeless insanity.
the soul-destroying reefer. Man, if that's not the creepiest laugh ever recorded. So, next we go to the Marijuana Tax Act of 1937. So the result of this hysteria was this act, and the MTA imposed licensing, registration, and stamp tax requirements that effectively made cannabis illegal. Anslinger drafted it in secret, few congressional hearings were held, and many congressmen knew little about it, nor had they even read the bill. Do any of these tactics sound familiar? The AMA, New York Academy of Medicine, and most doctors opposed the MTA, but nothing could stop Anslinger. And for once, New York actually got this right. New York City Mayor Fiorello LaGuardia adamantly opposed the MTA. He established the LaGuardia Committee in 1939, which in 1944 issued a report prepared by the New York Academy of Medicine debunking Anslinger's claims. The LaGuardia report found that, and I'll read the quote, "The practice of smoking marijuana does not lead to addiction in the medical sense of the word. The use of marijuana does not lead to morphine or heroin or cocaine addiction, and no effort is made to create a market for these narcotics by stimulating the practice of marijuana smoking. Marijuana is not the determining factor in the commission of major crimes. The publicity concerning the catastrophic events of marijuana smoking in New York City is unfounded." Undeterred, Anslinger continued his anti-cannabis campaign through the 1940s and 1950s. With the strong encouragement of Anslinger, in 1956, Congress included marijuana in the Narcotics Control Act of 1956, providing stricter mandatory sentences for marijuana-related crimes. Finally, in 1969, the United States Supreme Court in Leary v. the United States, yes, that Timothy Leary, struck down the MTA, but the reprieve did not last long. In October 1970, at the urging of the Nixon administration, in connection with its war on drugs, Congress passed the Controlled Substances Act, which defined marijuana very broadly and placed it under the most restrictive Schedule I, along with heroin and LSD. The placement of cannabis under Schedule I was intended by Congress to be temporary and subject to further research, to be conducted by the Schaefer Commission on Marijuana and Drug Abuse. This commission was specifically established for that purpose under the Controlled Substances Act. So it's a little bit of a dense slide, so I'll summarize it, but the Schaefer Commission found that marijuana was essentially harmless, and its findings included, among other things, no significant physical, biochemical, or mental abnormalities, no causal relationship between marijuana and subsequent heroin use, and no danger to public safety, and personal possession should be decriminalized as the actual and potential harm of the use of the drug is not great enough to justify an intrusion by criminal law into private behavior. So Nixon went into a panic to manipulate its findings. Failing at that, he rejected the commission's findings outright, thus leaving cannabis stuck in Schedule I, where it remains today. The saddest part of this is the reason. And this is a quote from Nixon aide John Ehrlichman. I think it was in an interview from the early 1990s. And he says, and I'll read the quote, "You want to know what this was really all about? The Nixon campaign in 1968 and the Nixon White House after that had two enemies, the anti-war left and black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war or black, but by getting the public to associate the hippies with marijuana and blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. Did we know we were lying about the drugs? Of course we did." It's just terrible. And in the Watergate tapes, Nixon has an exchange with H.R. Alderman where he blames support for the legalization of marijuana on Jewish psychiatrists out to get him. Like, yeah, okay. So now we start getting into some of the federal programs that we've seen over the years. So since the passage of the Controlled Substances Act in 1970, despite the failure of the federal government to implement the findings of the Schaefer Commission, the federal government itself has often recognized the benefits of cannabis. Since 1978, the federal government has subsidized cannabis for at least 15 medical patients under its investigational new drug program. All patients studied have reported improvement, and no serious side effects were ever reported, and that's since 1978. In 1988, an administrative law judge ruled that cannabis should be rescheduled, and that, cannabis constitutes a treatment for several medical conditions, and it's one of the safest therapeutically active substances known to man. Also, in a 1999 patent application covering cannabinoids as antioxidants and neuroprotectants, the federal government, citing studies and academic papers, represented to the U.S. Patent Office that cannabinoids are found to have a particular application as neuroprotectants. For example, limiting neurological damage after strokes and trauma, or the treatment of neurodegenerative diseases such as Alzheimer's and Parkinson's disease. I mean, we're talking about the federal government tried to get a patent on cannabis. So in 1996, California becomes the first state to legalize cannabis for medical use. Currently, as it stands today, 36 states and 4 out of 5 U.S. territories, Guam, Northern Mariana Islands, Puerto Rico, and the U.S. Virgin Islands, and the District of Columbia, still prohibited in American Samoa, have legalized cannabis for medical use. 19 states, the District of Columbia, the Northern Mariana Islands, and Guam have legalized cannabis for adult use, Connecticut being the most recent, legalizing last week. They put in place a similar bill to New York, and I think what we've seen so far is that New York, New Jersey, and Connecticut have been trying to sync up on their policies and what the regulations are going to look like. So pretty exciting that we now have all 3 pieces in place in the northeastern part of the country. So cannabis legalization is also spreading worldwide. The recreational use of cannabis has been legal in Canada since October 2018, when the Cannabis Act was signed into legislation. And all that said, it's legal in 36 states for medical use, and adult use in 19 states, and legalization efforts around the globe are progressing. But this has created this worrisome paradox for the roughly 72% of Americans who live in states that permit medical or adult use of cannabis. And despite being legal under state law, it's still illegal under federal law. So what are some of the things that have happened at the federal level over the last decade? So some key points. Under former President Obama, the DOJ issued the Cole Memorandum in 2013. The Cole Memo acknowledged that although cannabis is a Schedule I controlled substance under the Controlled Substances Act, the U.S. attorneys in states that have legalized cannabis in some form and have established regulatory and enforcement systems should limit the use of the U.S. federal government's prosecutorial resources by focusing on certain priorities. These included big-ticket items such as preventing the distribution of marijuana to minors, preventing revenues going to criminal enterprises, gangs, and cartels, preventing the diversion of marijuana from states where it's legal under state law in some form to other states, and a couple of other things like drug driving and growing marijuana on public lands. So in 2018, while those protections lasted a few years under former President Trump, former Attorney General Sessions rescinded the Cole Memo in January of 2018. Doing so, he added to the uncertainty of U.S. federal enforcement of the Controlled Substances Act in states where cannabis use is legal and has been regulated. At the same time of his rescission, Attorney General Sessions issued his own memorandum, the Sessions Memorandum. The Sessions Memorandum explained that the Cole Memo was unnecessary due to existing general enforcement guidance adopted in the 1980s, as set forth in the United States Attorney's Manual. The manual the manual's enforcement priorities, like those of the Cole memo, are also based on the U.S. federal government's limited resources. In 2014, we saw the Treasury Department's Financial Crimes Enforcement Network issued a memorandum providing guidance to clarify the Bank Secrecy Act and expectations for financial institutions to provide services to marijuana-related businesses. In essence, the FinCEN memorandum was the Treasury Department's own version of the Cole memo, advising financial institutions how they could provide services to cannabis businesses that are technically illegal under the Controlled Substances Act. Also in 2014, we see Congress has passed Appropriations Bills, which have been included amendments known by many names over the years. And these have been known as the Rohrabacher-Blumenauer Amendment, the Rohrabacher-Farr Amendment, and Joyce Amendments. And these have been passed every year since 2014. And I'll dig into this a little bit later because it's a critical point. Also in 2018, the 2018 U.S. Farm Bill was passed as the successor to the 2014 U.S. Farm Bill. And I'll dig a little bit deeper into that too. In December 2020, we had some historic action. The U.S. House of Representatives voted in favor of the MORE Act, and this vote marked the first time in half a century that a chamber of Congress voted on a bill to end the federal prohibition of marijuana. The MORE Act is one of the most robust marijuana reform bills ever introduced into Congress. And if it's enacted, the MORE Act would end the war on cannabis at the federal level by removing it from the Controlled Substances Act and ending criminal penalties under federal law. Even though it didn't pass the Senate on its last go-around, there are continued efforts to get the MORE Act through. So on a more general note, as of today, the current Biden administration's acting attorney general, Monty Wilkinson, has not issued any statements or guidance on medical cannabis since beginning his service as acting attorney general on January 21st of 2021. So we're still waiting to see if, where we go from here. So to kind of go back to what I was saying, ultimately, the only solution to the federal law cannabis problem in Congress is in America is Congress, and they're the ones that need to fix this. As scary as a thought as that is, if cannabis were rescheduled to Schedule 2, the FDA would close down all state legal medical cannabis companies. The only solution is for Congress to enact a new regulatory scheme for this special plant, similar to what it did for dietary supplements and tobacco, i.e. the MORE Act would be a good example of some sort of legislation to do that. Until then, the greatest protection to participants in the cannabis industry comes from the annual riders to the federal budget bills, which prohibit the Department of Justice from using any funds to prevent states from implementing their medical cannabis laws. So since 2014, the United States Congress has passed appropriations bills that have included these amendments. So for now, the Joyce Amendment is the only statutory restraint on the enforcement of federal cannabis laws. Federal courts have even relied on this to stop prosecutions of state-compliant cannabis companies providing temporary protection to the industry. This legislation only covers medical cannabis, though, so that's an important point. It doesn't cover adult-use cannabis companies, and it expires concurrently with each annual budget unless it's extended or renewed. So far, it has been every year since 2014. So I don't want to spend too much time on the 2018 U.S. Farm Bill, since it falls somewhat outside of the scope of this conversation, but I'll summarize some key points. So with the passage of the 2014 Farm Bill, Congress took a small step toward changing hemp policy. First, it authorized low THC industrial hemp. As a result, domestically grown hemp became available under state pilot programs. Interstate transportation of legally produced hemp was also made legal. Second, the 2014 Farm Bill drew a critical distinction between hemp and marijuana by defining industrial hemp as the cannabis plant sativa and any such part of the plant with a THC concentration of not more than 0.3%. Because the primary goal of the 2014 Farm Bill was to generate hemp research and protect its cultivation, the law didn't expressly address two really important things: the processing of hemp, or the manufacture, distribution, and the sale of products made from hemp. And most importantly, it didn't modify the Controlled Substances Act to properly exclude hemp as a Schedule I substance. So then we jump to the 2018 Farm Bill, which fills in the gaps left by the 2014 Farm Bill. And it clarifies that hemp and hemp products are in fact legal. While the hemp provisions may be short, they're powerful in their own right. The 2018 Farm Bill amended the Controlled Substances Act to remove hemp from the definition of marijuana in the Controlled Substances Act. It also created an exception for THC in the definition of hemp, meaning that so long as the THC concentration of the plant does not exceed 0.3%, the plant is legal. There's still a number of issues with the implementation of the 2018 U.S. Farm Bill as it relates to hemp, including it does not remove all barriers to the production and sale of CBD products made from hemp, whether hemp businesses are subject to a state's cannabis laws, if such state has those laws, various FDA hurdles, including marketing issues and prohibitions on making therapeutic claims. So there's a number of issues that still need to be addressed in the rollout of the 2018 Farm Bill. So now, the moment you've all been waiting for. Let's talk about the new legislation in New York. So I have to give some disclosure here. At this moment in time, only so much can be said about the recently signed bill, which, among other things, establishes a state legal adult use cannabis market in the state of New York. Until the final regulations are published, any of the following may change, and as such, the remaining portion of this presentation is subject to the publication of those final rules. So, to give a quick overview of this discussion, we'll be talking about what is the Marijuana Regulation and Taxation Act, what kinds of licenses can you expect to be issued, and the limitations imposed on them, who will be running the cannabis industry in the state of New York. I'll also take you through a rough timeline of how we get to the first adult use sales in New York. We'll also talk about some municipality-specific matters, social equity programs, and taxing the sale of cannabis in the state of New York. Finally, I'll give you an overview of what we can do to get ready while we wait for the final regulations to be published. So, what is this marijuana law that everyone's talking about? On March 31, 2021, New York Governor Andrew Cuomo signed into law the Marijuana Regulation and Taxation Act, which establishes a state legal and regulated adult use cannabis market. It sets up the framework for the new regulators to operate within when they establish this final set of regulations that everyone's so eagerly awaiting. The MRTA also amends New York's existing medical cannabis and hemp programs. And although this legislation is complex and leaves many unanswered questions, the most fundamental thing to know is that it is now legal in the state of New York for those who are 21 and over to possess up to 3 ounces of marijuana for personal use. Also, the MRTA does permit home cultivation. I'll point that out. So New Yorkers 21 and over can grow up to 6 plants in their home for their personal use, 3 mature plants and 3 immature plants. I think the maximum per household is 12 plants. But the catch here is this is only going to be permitted 18 months after the first adult use retail sale. So we're talking about probably 2025 or longer. So, Next, we'll talk about what kinds of adult use licenses were established by the MRTA. And if you look at the slide, you can see 11 of them. And I'll point out a few key things, and then we'll dig deeper into this shortly. But at the moment, we have no idea of the total number of licenses that will be awarded and whether there'll be any limitation or cap on the number of licenses to be issued. We do know that New York has set a goal to issue up to 50% of its licenses to social equity applicants. There are licenses just for registered organizations. That's the term that's used for medical cannabis companies already licensed in New York. The bill included on-site consumption licenses as well, which I think is pretty cool. This is something that's not yet permitted by every state, but is being pushed. It's being pushed for around the country, so there's a movement for it. I believe these licenses were just approved in Nevada. There's also something called a micro business license, which sounds like it's designed to model the craft beer industry. Two things to note about that. Early indications point towards these licenses being used to assist social equity applicants. And the big value here is that these licenses permit a company to be vertically integrated, meaning a company can operate what we call seed to sale. In other words, they can cultivate, process, distribute, and sell their own cannabis. Otherwise, this vertical integration is generally prohibited other than for certain registered organizations. And at the moment, there's only 10 of them. So, in addition to regulating the adult use cannabis program, the MRTA governs the medical cannabis and hemp programs as well. And as you may know, medical cannabis is already legal in the state of New York. I believe this bill added the cannabis research license and hemp, which is also legal in New York already. But these licenses that you see on the screen, they already exist today and can be applied for right now. So as I previously mentioned, there are limitations on vertical integration of adult use cannabis licenses in New York. And the idea here is that, generally speaking, your businesses will go one of two ways. It's either going to be involved in cultivation, processing, and or distribution, or it will be involved in retail. The exceptions here are micro businesses and registered organizations, which, as I mentioned, can be vertically integrated. But I think it's important to note some of the key limitations here. So for cultivation, processing, and distribution, a person can only have one of these licenses. However, a cultivator is permitted to have a nursery license, processor license, and distribution license, as well, meaning that these four licenses can be combined together. So it's not vertical integration, but it's still not bad. So while a person can only hold, let's say, one cultivation license, it can have multiple locations for its cultivation operations. Now, admittedly, there are many questions to be answered by the final regulations, so we'll need to see how these rules get filled out. So we'll keep on top of that. So in addition to the licenses I just spoke about, there's several other licenses too. And we already touched on some of these, like registered organization licenses and micro business licenses, but a couple of things to point out. A person can only hold one delivery license, and it cannot be combined with any other license. No one knows if any geographical limitations will be imposed on holders of these licenses, so that remains to be seen. A retail dispensary license, a person can have up to 3 of these. Again, there are many questions to be answered, like for on-site consumption, can retail sales be made at these locations? This may be a fine line between success and failure. We don't know at the moment. We do know at the moment that these need to be separate from bars serving alcohol, but we don't know much beyond that. So there's a lot of questions to be answered. Some other quick facts about medical license limitations. So as I mentioned, there's currently 10 registered organizations in New York. Each RO is permitted to have 4 medical dispensaries, but the MRTA allows them to expand to 8. Only up to 3 of their medical dispensaries can have an adult use dispensary. None of them can be adult use only dispensaries, though. And ROs can only distribute their own products. And that's an important point, too, for adult use, is that cultivators who also own a distribution license can only distribute their own products. So who's running this thing? It's a hot topic right now. The MRTA creates a new office called the Office of Cannabis Management, which will be governed by a Cannabis Control Board. The Office of Cannabis Management will oversee and implement the law. It's created as an independent office within the Division of Alcoholic Beverage Control. Think of this as similar to how the State Liquor Authority oversees alcohol in New York State. The OCM will regulate cannabis and will issue licenses and develop these regulations outlining how and when businesses can participate in the new industry. The Cannabis Control Board, that's going to consist of 5 board members with 3 appointees from the governor, 1 from the Senate, and 1 from the Assembly. The Cannabis Control Board will, among other things, issue licenses. It can limit the number of licenses to be issued or choose not to limit them at all. It can inspect licensees, and it can create applications and set periods of time when applications can be accepted. The Office of Cannabis Management will exercise its power through an executive director who is nominated by the governor with the consent of the Senate. The executive director will be charged with carrying out the day-to-day administration of the OCM, including record keeping, inspecting the premises of any license holder, and advising and assisting the Cannabis Control Board. So the Cannabis Control Board and the OCM, there seems like there's some overlapping authority, but they're going to work hand in hand on many of the same matters. But the CCB, the Cannabis Control Board, seems to be the group driving the policy decisions. The Cannabis Control Board will also appoint a chief equity officer who will oversee the social and economic initiatives of the OCM, assisting with the development and implementation of social equity programs, including educational programs for potential applicants. And then finally, there's going to be a Cannabis Advisory Board, which will be comprised of 13 voting members with 7 appointments from the governor, 3 from the Senate, and 3 from the Assembly. This group will primarily advise and issue recommendations of the use of medical and adult use cannabis and hemp in New York State. It's going to govern and administer the New York State Community Grants Reinvestment Fund. That's a fund that's going to provide grants to nonprofits and local governments and communities that have been disproportionately impacted by cannabis prohibition. So the hot topic the last few weeks has been, who will Governor Cuomo select to be the chairperson of the CCB, which is the first tangible step towards a functioning cannabis industry in New York. And to further drive this point home, let's talk about the timeline to get the first adult use sales in New York, which is already being delayed by the lack of CCB appointees. I think I skipped a slide. My apologies. So there's no clear timeline for the publication of final rules or acceptance of applications in the MRTA. New York Assembly Majority Leader Crystal Peoples-Stokes estimated that the first legal sales of adult use cannabis will be between 18 months and 2 years after the signing of the MRTA, which puts it somewhere between September 2022 and March 2023. Some other key dates are the tax-related provisions for adult use cannabis sales will become effective April 1st, 2022, and the current medical cannabis cannabis laws are automatically repealed 6 months after the CCB is fully established. Also important is the expungement of certain marijuana convictions are to occur no later than 2 years after the signing of the MRTA, which is pretty cool. So working off the New York Assembly Majority Leader's 18 to 24-month timeline, we've mapped out this slide, which shows what it would take to have adult use sales in that time frame. And since the proposed 18-month timeline assumes that the CCB will be filled by June 2021, unless that happens or happened while we were speaking, or unless it happens tomorrow, which is not likely since the legislature is not in session, her timeline will be shifted. We have to account for that in this timeline. So as we know, the MRTA was signed into law on March 31st, 2021. Assuming regulators are appointed in July, then if the board were to act fast, proposed rules could be issued as early as August 2021. The earliest possible dates after a 60-day notice period and comment period would put public hearings in September to October of 2021. Final rules would then be issued approximately November 2021. And applications would then need to be accepted by January 2022, which means that licenses would need to be granted by April 2022, meaning legal sales could start around October 2022. This is a tough timeline, but we'll see. So I'll speed it up a little bit. So to talk about some local municipalities and some related issues arising from the MRTA. Critically, at this moment, municipalities are not permitted to issue local licenses to cannabis licensees. We see in some other states like California that this makes for an incredibly complex and cumbersome licensing process. So the fact that New York did this is a good thing. Generally, all local governing bodies are preempted from banning ROs and hemp licenses and have the limited ability to ban certain adult use license types. Localities can only ban retail dispensaries or on-site consumption licenses. That's it. Municipalities can opt out by December 31, 2021, but this can be overturned by a permissive referendum. What this means is if they don't pass it on, if they pass it on January 1, 2022, it's going to have no effect. So you got to do it before December 31 of this year. If a town opts out, it's going to lose its apportioned tax revenue. And importantly, opting out does not appear to prohibit delivery. So we'll have to see if that changes in the regulations. But municipalities may, however, pass local laws and regulations governing time, place, and manner of the operations of these licensed retail dispensaries and on-site consumption sites, as long as they don't make the operations impractical. Okay, so moving on, an important aspect of the MRTA is its social equity component. And New York is proud of these provisions, and the general consensus is that if these laws are implemented as intended, they're going to be a game changer for the industry, which is made up of many people who have been adversely impacted by cannabis prohibition and similar laws. Other states have attempted these programs, but this is the first time where social equity laws are baked in from day one. I'm pretty sure Connecticut has something similar here. So, in addition to the expungement of certain marijuana convictions, New York is aiming to repair the damage caused to disadvantaged, mostly minority communities by the prosecution of marijuana laws in the past. It's also supposed to provide opportunities for minority and women-owned businesses, disabled veterans, and distressed farmers. An extra priority is going to be given to those persons who have been convicted of marijuana-related offenses in the past or had an immediate relative who was convicted of the same offense. It also will give priority to those persons who have an income lower than 80% of the median income of the county in which the applicant resides. So the OCM is going to actively promote these social and economic equity applicants who have been harmed by the prohibition of cannabis for adult use licenses. And the goal is to award them 50% of the licenses to be issued. So in addition, this legislation will establish these equity programs that will provide loans, grants, and incubator programs to ensure broad opportunities for participation in New York's cannabis industry by those people from communities that have been disproportionately impacted by marijuana prohibition. So as part of these incubator programs, fees can also be waived or reduced. So there's going to be some benefits to these applicants. So let's talk briefly about the taxation of cannabis in New York. MRTA established 3 taxes on adult use cannabis, including a new and innovative tax applied when a distributor sells to a retailer. It's based on the THC content and the type of the product. I'll give you an example. Edibles, which are food and beverages usually, are taxed at 3 cents per milligram of THC. On the retail side, on the retail sale to the consumer, there are also 2 taxes, a 9% state excise tax and a 4% local excise tax. Now, these taxes do not apply to medical cannabis. So all cannabis taxes that we're talking about here are going to be deposited in this New York State Cannabis Revenue Fund. And this fund, after it covers administrative costs to run the program and implement the law, the remaining fund is going to be split 3 ways: 40% to education, 40% to community grants, and 20% to drug treatment and the public education fund. So now I will give you some fun facts and market projections, and we're almost done here. So 239 million Americans live in a state with medical cannabis. That's 72% of the population in America. 141 million Americans live in a state with adult use cannabis, which is 42% of the population. In 2020, the total combined sales of cannabis across all legal markets crossed $20 billion. And by 2025, total cannabis industry sales are projected to reach $43 billion, assuming that a few more states come online. This is a projected growth at a compound annual growth rate of 16%. Also, the governor's office has estimated that by 2023, New York will have achieved $1.2 billion in sales and $350 million in total tax revenue. So finally, I will leave you with this. What can you do now? And some preparation tips. So until we see the final regulations, which may be a while, let's talk about what you can do. You got to figure out what you want to be. Will you be a cultivator? Will you own a retail dispensary? Will you have an on-site consumption lounge? Oftentimes when we talk to someone who's eager to get involved in the industry, they realize that they never wanted to be a cultivator or a processor and find that retail is more fitting, or vice versa. Management team. Get your management team in place. Who will run your day-to-day operations? Who's going to maintain your books and so on? Real estate. Although the local opt-outs add a layer of complexity to finding real estate, companies are already buying up property in anticipation of receiving a license. One company just bought an abandoned prison to set up their cultivation operations. So start thinking about where you want your operations to be located. Get active, become an engaged civic member of your community. Think about social and economic equity programs. Assess whether you or your potential business partners qualify for social equity licenses. Get out-of-state experience. It's important. Many multi-state operators are here already, and many are eagerly waiting to apply. If you can't get the experience, if you can get that experience in an established market, it could help your chances of getting a license in New York. Financing. We don't know how much the application fees will be, but New York has the right to charge a non-refundable fee for these licenses, and there's some gaps to be filled, but think about financing capacity and develop a pro forma model for startup and ongoing operations. And then finally, the shameless plug, call me. Not only do you need to get your management team in place, but you got to get your professional team in place too. Lawyers, accountants, licensing consultants, and other professional advisors are a critical part of this process. And we have a relationship with a licensing consulting company that assists our clients in the licensing application process. That's something that we like to quarterback. So call me. And I think that's it. So no problem.
It gives everybody a lot to think about, and I'm sure there are going to be a lot of questions. We do have a few with us already. For those of you who do have questions, don't forget to use the chat function on the Zoom program. If for some reason you see that it's disabled, I'm told just try and refresh the page, and it should come back. But Pat, I think we already have a couple, so why don't you start off?
Yes. So as you mentioned, Sean, considering the Cannabis Control Board and the Office of Cannabis Management have yet to be established, is there a way to find out what licensing is going to cost and which aspect of the different licensings will be there, so that we can start lining up our financing or savings accounts or you name it to get in? Is there industry standards in that field yet?
Yeah, so I guess I'll take that in two parts. So yeah, we're all eagerly awaiting the Cannabis Control Board and the OCM to be filled out, because like I mentioned in the presentation, that's going to be the first real tangible step to getting the final regulations, which is critical. That's what's going to give us a lot of insight. That's where the applications are going to be derived from. So once we have those applications in front of us, that's when we can give more definitive advice on these things. But we do have a medical cannabis industry that is already here. There's 18 other states that have rec markets already. I believe it's been a while, but I think the application fee for medical cannabis in New York was $200,000. And I think, I could be wrong, I think that was a non-refundable fee. But so I don't know, no one can tell you what the license fees are going to be. But, if you're a social equity applicant, those fees might actually be reduced. So, it could swing a number of ways. We don't know for sure, but it makes it all the more difficult in this moment to start getting ready for these things. But we could start looking to how other states have done it. I've been reading that our regulations are gonna, our bill that was just passed is similar to Colorado. But again, it's really difficult to put a number on what's going to happen with licensing fees.
Well, we want to thank Jan for submitting that question as well as her follow-up, which was why, Steve, you were inspired to wear a tie today, as you did not at the last show.
Moving right along, Sean, you and I spoke before the program started, but we have a question from one of our viewers, which has to do with transportation across state lines. If I want to, bring in cannabis from California, is that going to be a problem?
Yeah, no, that's definitely a problem. So remember, and this is a critical point of what I was talking about, is that cannabis is still prohibited on the federal level, meaning there are no crossing state lines right now. So if you have a cannabis company in California, that company cannot grow its product and sell it in New York. You need to become licensed in New York. You need to set up your operations here, and you cannot sell it outside of New York. So you are confined to that state in which you operate. So yeah, no, that is a no-no. No crossing state lines.
So we're going to be confined to selling homegrown stuff, huh?
That's right. Yeah, New York, and this is the way it is in every state. You are confined to, if you're going to be a New York licensed cannabis company, you will be cultivating here, you'll be processing here, distributing here. Delivery services are only going to be in New York, so you can't, go through the tunnel and get to New Jersey. You can't cross the bridge to Connecticut. I mean, you are confined to New York. You cannot cross state lines.
Interesting. Sean, I know some of the motivation and the appeal were those that see this as a social justice issue and a social justice win, and in position to help communities of color who are disproportionately affected by the war on drugs. Others are concerned about downtowns in the same communities becoming home to many different retail cannabis stores that ultimately may not be good for the community. Mm-hmm. What are your thoughts on this balancing act that the state is going to try to pull off?
Well, what I can say is just listening to our New York Assembly people and the Senate, this is a high priority item for them. The social equity component of this is, in their minds, this is a game changer. This is something that other states have tried to already implement, but seemingly have failed. So this is something this is very important to them, and they're proud of these regulations. And I know that Connecticut just passed their bill, and I'm pretty sure that they've baked in this social equity component as well from day one, which is really important. So what I'd say is, first of all, we don't know where dispensaries and cultivation facilities are going to be located yet. There's all kinds of complicated zoning considerations that are going to have to be taken into account for. We don't know which town or which municipalities are going to opt out. But putting all that aside, what I would say is that a couple of years ago I read a study, and it examined facilities in Oakland. And I would think that Oakland fits the bill of the type of community you're talking about generally. And what they found is that in Oakland, when you had this cultivation facility set up, the security requirements are so stringent on these companies. Everything's in armored cars. There's cameras everywhere. It's well lit. So what they found in this study is that the surrounding area actually improved. So I'd offer that as well. There's some interesting studies out there.
Sean, I know your presentation didn't address this, but there are a lot of people in our audience who are local employers. Do you have any idea how the legalization of marijuana is going to affect the workplace from a legal standpoint?
That's a tricky one. I think the final regulations are going to shed a little more light on that. I think preliminarily what I've been seeing is that employers will still have some ability to prevent marijuana use by their employees. I think the effort is, that's being made right now is to change that, because there are people who, especially in the medical community, that truly need access to medical marijuana, and there are plenty of people who need it for their epilepsy. It's life-changing for them. Plenty of cancer patients who greatly benefit from this. So, there's got to be changes, and I think it's the Cannabis Control Board has the authority to start creating policy on what employment practices are going to look like. Unfortunately, I can't give you much more, but once we have the final regulations in place, I can give you a little more on that.
Terrific. So, Sean, we want to thank you again on behalf of the MacArthur Business Alliance for joining us. I'd like to remind our viewers that this will be posted on the MacArthur Business Alliance website, where you can view it and ask questions, and we will impose on Sean to provide us answers if we cannot. And we thank you. It's a pleasure to have you, and can see why you were selected as a 2020 and 2021 New York Metro Area Rising Star.
Thank you.
So we appreciate your time, as well as the shameless plug. And Steve, what do we got next?
We have some really exciting news for everybody. Next month, which is July, we're in June right now, on July 27th, we are going to be meeting in person at 4 o'clock for a presentation on project management. It will be at TechWorks Consulting in Ronkonkoma. Please mark it on your calendars. We will be having a networking and social component. So if you're ready to get out and see people again, please make sure that you're ready to come. There'll be more information in your inbox shortly. The headliner of that discussion will be Kevin Quinn, who is a local project management consulting business that provides grounded approach to project development, planning, and delivery of complex projects. We do have other folks who will be joining Kevin, and those will be posted shortly as well. And finally, I know some of you have been waiting to hear about the annual golf outing. It is still in the works. It is going to be another exciting event this year. It is going to be of limited space, and we will have that information for you shortly. But again, we anticipate it will be sometime in August.
Terrific. Well, thank you all very much for joining us, and we look forward to seeing you live and in person on July 27th for our next networking meeting. Thank you and good afternoon.